Okay.
Oh,
Ready to go, Ross, when you are.
Thank you, Lauren. Good afternoon and welcome to this meeting of the Northern Beaches Local Planning Panel. My name is Ross Bomthorne and I will be chairing today's meeting. Let me commence by acknowledging the traditional owners of the lands on which we meet today and by paying respect to the elders past, present and emerging. May I also welcome my fellow panel members and ask them to briefly introduce themselves. So, Kate, if you could start with a brief introduction.
Thank you, Ross. My name's Kate Bartlett. I'm one of the experts on the Northern Beaches Local Planning Panel. I'm a planner by trade and I've got about 20 years experience working both in local government and private sector.
Jason, if you could.
Jason Perica, also a town planner, science architecture degree and Master of Planning. Probably about 30 years, I think, experience in local councils and state government, including at senior levels, and then in private practice for the last 14 years.
And Philip?
Yeah, hi, I'm Phil Young. I'm the community representative, and I've had about 25 years representing the community in various roles, mostly as the chair of our local forum, and before that in the precinct system that Manly had.
Thank you. And just to clarify, my name is Ross Bomthorne. I'm an architect and urban planner. I've served on the City of Sydney Council and on the Pittwater Council and various other government agencies and committees and panels, as well as being employed by the Lend-Lease group of companies for some 29 years as the principal architect and as a board member. I would like to also acknowledge the council staff members that make these meetings possible and welcome members of the public that are present today. I will now like to, sorry, we have a slight sound problem, I think. I will now like to formally commence the Northern Beaches Local Planning Panel meeting for the 15th of October at 12:04 p.m. and move to the agenda. The first item on the agenda are apologies and declarations of interest, for which I have none. The second item, minutes of a previous meeting. The minutes of the Northern Beaches Local Planning Panel meeting held on the 17th of September. The recommendation is printed and that these minutes be adopted by the chairperson and have been posted on Council's website. Then the business meeting in the open session, we have 4 items. The first item is item 4.1, 20 quarter sections road at Church Point. I have a number of speakers who wish to address the panel. Let me remind those who would like to address the panel that you would have 3 minutes to make your presentation, and there'll be a buzzer that allows you to be informed that there is then a 1-minute time to sum up, if you would please. I'd ask if there's a listing of 8 objectives, perhaps if there is a repetition of information, then perhaps the speakers can be a little briefer so we are able to move on. There is also a request from the applicant to address the panel. So I'll start with Cassandra Brooks, if you're available. Cassandra, if you would like to address the panel, please.
Hello, can you hear me?
We can, thank you, Sandra.
Hello, good afternoon. My name's Cassandra Brooks and I represent my family of 5 who live at 11 Quarter Sessions Road. We've submitted 2 objections to this DA. We're in the immediate notification zone. I'm actually dialing in from overseas today whilst we're on our family holiday, just because I feel like it's pretty important and a significant impact on the wildlife and the environment in our area. I can't stress enough the importance of the quality of life this development risks, the joy my family, my children, and also our visitors get when they see a wallaby, an echidna, a snake around our home. We've got 3 young girls and we intentionally live in this less than convenient location so they can be immersed in nature. And this is exceptionally special and unique experience for us and all the residents who live here, and that's what makes our home and our area special. We're teaching our children to care for and respect the environment, and we believe it's important, especially in the current context we're living. Despite what the report implies, this seems to be a significant development, and we've seen firsthand how even small changes in our ecosystem can impact us personally. A new neighbour moves in who doesn't necessarily have an understanding of the bigger picture, and that removes wallaby sightings for our family. When we speak to long-term neighbours, you can see the sadness and the disappointment in their eyes as they share the drastic changes they've witnessed in both the flora and the fauna during their time here. Why has this become acceptable when the alternative is so valuable? We support thoughtful development that respects the area's rural residential identity, but this proposal in its current form has only explored 2 options, and we believe continues to be out of scale, out of character and out of harmony with community values, which the council is charged to protect. We're deeply aware of our impact on neighbouring properties, especially on such a steep slope for environmental, drainage and amenity purposes. And if other owners aren't considerate enough to do that themselves, council should protect the rest of the community. We are part of this community. We've already been impacted by the development, but in the eyes of council, it hasn't even begun. So in summary, I request that the panel reject the application, and if that's not possible, at the very least, if we can not limit the movement of animals in our wildlife corridor, that would be the most significant thing for us. Thank you for your time.
Thank you, Cassandra. Are there any questions from the panel for Cassandra?
And from me.
No.
Not for me.
Cassandra, thank you very much, and I trust you can enjoy your holiday.
Thank you so much.
That's all right. The next person listed is Marita McRae. Marita, hello, a long time.
Yes, hello, thank you for having me on the panel. My name is Marita McRae. I'm speaking on behalf of Pittwater Natural Heritage Association, which has been around for more than 31 years, raising awareness for our environment and helping to protect it. And we're concerned about the effect this development is going to have, if it goes ahead, on the natural environment of this land and its surrounds. My talk is in 2 sections. Firstly, about the trees, and I'm noting that although the modified plans to reduce the number of trees has reduced the number of trees to be removed, we're not convinced the remaining trees will not be impacted by the development. And we note that there will be encroachment into the structural zones of trees 69, 70 and 71. We note the Council's natural environment referral response about biodiversity, and that is apparently approving the modification of the DA. Now, the fate of the fauna and flora on this land now depends on the landowner observing and implementing the very many conditions imposed on the development in the process of construction and into the future. And I've got some questions that maybe the panel can take on board and answer when I finish speaking. The first question, who will oversee the observation of these conditions? Another question, what will council do if the conditions are not met? Any conditions you impose must last beyond a possible change of ownership of this property. And another question, what powers does council have to ensure these conditions would be observed in the future? And commenting, you must consider what will be the condition of this land and its fauna and flora in 10 years' time, or hopefully right into the future. Now, my second point is about the fence proposed. The proposed 1.8 metre timber lapped and capped fence within that land, parallel to the boundary with, I think it's number 18, will restrict wildlife movement through the landscape. And now, if cats and dogs are to be confined on the property for the safety of wildlife, which is to be done, then such an impervious fence is inconsistent with maintaining fauna habitat, native fauna habitat. The proposed holes to allow fauna to pass through the landscape are not big enough to allow wallabies and lace monitors through, and these animals are known to live in this area. The fence is not a property boundary. Any holes will need to be kept open by the property owner. Leaf litter and other material could block those holes over time, and it's quite likely. So the question, how will fauna passage through this fence be assured?
Thanks, Lauren. Just one more minute, Marita, and if you need a minor extension, that's fine.
Oh, thank you. I just think that some other privacy provision should be investigated to provide for fauna movement and without affecting the amenity of the next door property. So unless all those answers are satisfactory, I think this modified DA should be refused. Thank you.
Thank you. Any questions to Marita at this stage, or any comments on her request? Marita, I've tried to, sorry, Kate.
Oh, sorry. Through you, Chair, just some of those questions the council officers might be able to assist in answering in terms of things like who's in charge of ensuring compliance with conditions and things. And that might be useful to answer some of those now, if that's helpful.
Thanks, Kate. I was going to ask the same question or have the same thing, because I think it makes it easier in making it transparent and very clear to the community. So, Peter, if you are able to, or another staff member.
Yes, that's fine. In any development application, it is followed by a construction certificate. The building works are usually managed by the project manager or the owner. Compliance with the conditions during the building work and issuing the occupation certificate is the certifier that the applicant nominates. Council can become involved in any non-compliances with conditions or with the plans. It's usually dealt with between the certifier and council in dealing with that.
So, Peter, some of that is very clearly indicated in the report, in the conditions.
Generally, no. It's the certifier who takes over the role of
but the actual
management.
role, the function, the way in which it proceeds, which I think, Marita, was what you were interested in understanding.
Yes.
So the way, there are conditions in there that would require certain things to happen, and it is the certifier who is to ensure that that is to happen. If they're not, then the certifier can issue a notice of intention, and then council can issue the orders following that.
All right, thank you. Are there any other comments, Jason or Philip? Do you have any other comments?
No.
I think that there will be further comments that emerge with other speakers. So if I may, thank you, Marita, for your input. And as I said, good to see you. It's many years ago.
Yes, that's right.
In the days when there was a Pittwater Council. Thank you.
Yes.
Anyway, the next request to speak is from Craig Burton, if Craig is with us.
Hello.
Craig, if you'd like to address the panel, 3 minutes and a buzzer, and then another minute to sum up, if you would, please.
Okay, thank you, Ross. So I'm also an architect, a landscape architect and a heritage consultant. And I've been resident of Scotland Island for the last 53 years. And I was one of the members of that prepared the heritage study in 1988 for Pittwater to succeed from Warringah, and we're hoping that Pittwater will get back. But my main concern is the naturalness of the landscape setting. And I'm concerned about this particular development. One, and this reiterates a little bit of Marita's in a way, is that the naturalness is affected, the trees are affected by the siting of the pool. The pool could be sited closer to the building and we could save a few trees. The trees are in there, impacting them directly. The stepped terraces on the slopes with retaining walls that are not detailed could affect downslope drainage and affect the tree canopy of the remaining bits of Pittwater spotted gum forest. My other concern is the landscape design is atrocious in terms of its communication there are plans, colourful plans with no legends. There's areas of large green. There's no plant schedule other than 2 trees. We don't know what happens in the dark green area, and I'm assuming it's mass planting, and there's no details about that, about the species, the density, and so forth. And there's a great scope for restoration of the Pittwater spotted gum forest. And that leads me to the fact that if you look at the green areas on the landscape plans, the various landscape plans, it's very confusing. But you don't know what's existing and what's proposed. And of concern is the solid fence along the boundary with number 18. And I have the same issues about flow, airflow, views, flow for wildlife. There is, as Marita said, there's a regular visitation of all sorts of wildlife if they can't get through on a solid fence. And so I think that should be reconsidered. I think the pool should be reconsidered in its siting. And to achieve, I'd like to see some more shrub layer for birds, rather than they've just got species nominated. There's only 3 species nominated, and they're either herbaceous plants or climbing plants. So,
1 more minute, please, Craig.
So, well, in summary, I think that this scheme should be rejected and reconsidered. Thank you.
Thank you, Craig. Any questions from the panel to Craig or comments? No? Craig, thank you very much. No doubt you'll listen into the further comments that come. And I have a listing. Deborah Collins. Is Deborah with us?
Yes, I am. Thank you very much.
Deborah, thank you. If you could address the panel, please.
Yes, thank you for the opportunity. My name is Deb Collins. I'm the convener of Canopy Keepers here in Pittwater. Canopy Keepers is committed to the preservation and regeneration of our significant tree canopy, including the endangered ecological community known as the Pittwater and Wagstaff Spotted Gum Forest, which covers the area in question. We have been approached by a number of residents from within this sensitive ecological community who have shared concerns about the proposed development before you today, and we share their grave concerns. In fact, as an organisation, we're contacted fortnightly by residents across the LGA who are concerned about the loss of mature, high-value trees, changing our urban forests and our precious wildlife corridors forever. Many residents are reluctant to formally object due to fear of neighbour conflict, or are themselves overwhelmed by complex documentation and regulations as they witness ongoing canopy decline in areas like this in Church Point. This development, like many we look at, threatens such high numbers of trees and could change forever the contiguous canopy cover in Church Point. As concerned residents, we support Council's effort to maintain and enhance our urban canopy. And together we look to the planning panel with hope in a final assessment point to thoroughly review the very serious impact of this and other developments. This is an ancillary development of a pool and cabana. The point we wish to stress is that 46 high category trees could be irreparably damaged as part of the construction works for this project. So we ask, who will, as others have, ensure that these trees are not damaged? We say the risk is too high, and I refer the panel to the detailed objections that you've reviewed on this DA to appreciate the presenting risks to the trees on this block. I trust it is well known among council staff and this planning panel that private certifiers on the whole show insignificant regard for the protection and care of trees during construction. This reality has been documented and presented to council by canopy keepers and level 5 and level 8 arborists in our team many times. Council acting to bring these developments to compliance is slow and most often too late to avoid the damage done. This pattern of neglect by certifiers has led to serious environmental impacts in Pittwater with lasting consequences. And a prime example of this is the development on the corner of Sanders Lane and Allura Road in Avalon. Therefore, we are not asking for added conditions because we do not believe that these will be met. There's a chainsaw in the background as we speak. I will. We ask that this development is rejected. These endangered ecological communities are rich pockets of critical biodiversity, and they're facing a very high risk of extinction in the near future in our LGA. With an indicative timeframe of 20 years, the time to protect these ecosystems is now, not in 5 years' time. Thank you.
Thank you very much. Any questions or comments for Deb?
No.
Thank you. Thank you very much, Deb, for your attendance and for your comments today. The next person I have listed is Emma Capel. Is Emma with us? I'm not sure, Lauren, whether you've got Emma.
I can see Emma in our lobby.
Yeah. Hello, can you hear me?
Yes, Emma, thank you.
Yes.
We thought we may have lost you. Thank
Sorry,
you.
no, I'm not very good with these systems. A bit nervous as well. I hope you might give me a little extra time because I'm a few words over. But anyway, does it start now?
Yes, please.
Okay. I have resided very near the subject property for 26 years. A severe rain, and I have personal and historical knowledge of what goes on. A severe rain event in 1989 devastated Church Point, this subcatchment, more than any other part of then Warringahshire Council, and it compelled Council to allocate emergency funds of £1.5 million to provide stormwater management infrastructure between Bayview Heights and Pittwater, which of course this subject property is. As the critical infrastructure remains undelivered, any developments in this area must be very carefully managed to avoid property destruction downstream. I must here an example to emphasise what happens when upstream developments non-compliant with Council's water management for development policy are approved. Overtax compliance staff often define the resulting damage as a private matter, thereby placing neighbours in civil conflict. Prevention is better than cure, and I would like this to be rejected. My property has sustained, while there, 3 landslips, 5 toppled mature hardwoods, loss of 30 trees that I planted in 2001, destruction of my cubby house and major soil erosion. And in 2011, when part of my driveway collapsed, Pittwater Council replaced it in recognition of their culpability in the matter and sought then, as in 2023, drainage solutions for me, which were rejected on economic grounds. As the immediate uphill area for this development lacks council stormwater infrastructure, residents in a group offered to pay for stormwater drains at Captain Hunter Road directly above, but this was rejected by council, stating there is nowhere for the stormwater go, that is, except to flow uncontrolled downhill, such as over myself. This extra runoff must be taken into account when considering private developments. Overdevelopment allowing a greater impervious surface causes exacerbated peak flows, which cumulatively cause immense damage to downstream properties like mine, as the stormwater is not absorbed in this clay soil. This development seeks variance to minimum landscape requirements to receive those flows. I totally reject the stated merit consideration that sufficient soft surface is provided to allow for infiltration of water, minimize runoff, and assist with stormwater management. The prevalent clay soil here is a poor media for absorption and percolation of stormwater. Runoff consequences are cumulative and exponential. As each tree is lost, the next tree is destabilized. I frequently record the consequences of cumulative stormwater runoff from multiple uphill developments in literal torrents over my driveway that shock any viewer except for council, it seems, who say it's private matter. Council engineers and planners must study and consider the collective impact of proposed increases in discharge, which has been neglected on multiple developments in the subcatchment already. The only reference to stormwater management in this DA relies on existing systems, which has happened above me as well, without providing any detail of those systems. What is the current legality of those systems and their ability to safely receive and relay the stormwater? and accept the stormwater. I suffer the effects of DA's approved to an existing system. Engineered stormwater plans, including this information, should have been provided by the developer before the DA could have been considered. How can council closely monitor stormwater systems if there are none? Thank you for listening, and please understand that the concerns expressed regarding stormwater drainage have real consequences for all downhill residents, and I am living proof. I demand that it's rejected, and at the very least, they need to submit stormwater plans. Thank you.
Emma, thank you for your presentation. And are there any questions from the panel? Thank you. I have further speakers, and again, Emma, thank you very much for the work that you've done in the preparation and informing us of your involvement over the years.
Just trying to mute myself.
All right, thank you very much. Anyway, the next speaker, Pamela Alexander.
Good afternoon.
Pamela, thank you. If you could make your presentation to the panel. 3 minutes and a minute to sum up, if you could, please.
My name is Pam Alexander. I live with my husband, John Alexander, within the notification area for the proposed development. I have lived in this house in Church Point for 40 years and have been an active community member during that time. This is the first time I have ever objected to a development application, and it's certainly the first time I have ever addressed a panel. I am appalled and outraged by this proposal and would never have anticipated having to defend the things I am today. There are others who are far more knowledgeable than me regarding the environmental impacts, but what I am totally taken aback with is that a solid fence such as this could be proposed and then recommended for approval by our council, given that it is against planning controls. This will have such an inequitable impact for our neighbours at 18 Quarter Sessions Road. The justification that it is in keeping with the other properties in the area is simply not true. The assessor has cherry-picked the smallest percentage of fencing in comparison to the majority of either low-lying or semi-permeable fencing. In this area, vegetation is used as fencing where required. I believe this is actually the exact wording in the DCP. This has permitted the true free passage of animals to be maintained. We have long revered where we live, low-density, rural, bush environment. If this fence is approved, it will be used as a precedent for other fences, and how absolutely awful that would be. The holes suggested are indeed laughable. They will be clogged in no time due to the immense amount of leaves, and debris that falls every day. Ask my husband, John. He cleans up every day. We are in a fauna conservation area, and the topography, landscape and animals we have here mean the minimal openings are wildly inadequate. The privacy it would afford either property is minimal. If you have visited our street, you will acknowledge we live on a significant incline. There will be a hedge, and much of the fence will be in between a solid brick wall at the back of number 18 and a large rock retaining wall for number 20, both of which are higher than the proposed fence. There are no photos of this in the assessment for the panel to view. It would also be a fire safety risk, both in its current wooden form and in any solid form. I cannot imagine how I would feel if this was proposed along 60% of my property boundary. Devastating comes to mind. I do hope the panel can see the sense in these objections. Thank you very much.
Thank you, Pam. Any comments or questions for Pam?
I had one.
Yes.
Ms. Alexander, you did mention that you felt the fence that you don't support is contrary to the planning controls. I'm just interested which specific control you'd be relying on to not support the fence.
Well, you've caught me because it was previous paperwork that I read and handed back. I'm not sufficiently.
No, that's all right. I'm not trying to catch you out or anything like
no.
that. I'm just interested in trying to understand if the controls that would be relied on to not support the fence. That's all right. That's okay. I can direct those queries elsewhere. Thanks.
Thank you, Jason.
Thank you. Any further comments or questions?
No, yes, just through you, Chair. Oh, sorry, just a question.
Hey.
Is number 18 actually speaking at the meeting today? It would
Yes,
just be good to
there is.
understand their opinion on the fence.
I think Miss Hiscox is listed as number 8 to speak. And I believe
I'll
her.
wait for that then.
Okay, I believe that she represents number 18 Quarter Sessions Road. That's on the list, which is the next speaker, or we could bring her forward if you like. And
No,
so
happy
actually,
for it to go in normal order.
all right, thank you. The 7th person listed is, and I'm sorry if I mispronounce this, Carrie Ann Rosenberg. Carrie Ann or Lauren, do we have her listed? Or we have her
Yes,
listed, but is
yes.
she present?
Yeah, I can see I think it's Karen in the lobby. I think I can see her there. She might be away from her screen at the moment.
Well, let's come back to her. Perhaps if Alison Hiscox is there, she is, I believe, the owner of, or the resident in number 18.
Yeah, the owners, one of the owners. Can you hear me okay?
Yes, thank you. Thank you.
Okay, thank you. Hi, we're the neighbours most directly impacted. Our rights and values under the zoning aren't being protected. Several concerns must be resolved before this DA can proceed. The fencing is against controls, impacts us significantly and should be removed. Missing plan details will cause further negative impacts which should be addressed through conditions. The landscaping area falls short. The path currently under assessment for compliance should be removed to compensate. I'll take you for a walk through our home to give you an idea of the impact of the 33-metre fence, which would cover 60% of our boundary. This wasn't on plans when the assessor visited our home. From our main inside area, our cherished views are of the bush and filtered water. At night, it's pitch black. This will be replaced with a 1.8-metre solid fence. Sorry, can I just ask the time can other speakers be muted? I can hear background noise.
Is that okay now, Alison?
We can try. Sorry, I'll continue. From our main inside area, our cherished views are of the bush and filtered water. At night, it's pitch black. This will be replaced with a 1.8-metre solid fence and then a 2.3-metre above ground pool, which is not well below the natural height of the environment. This isn't view sharing or minimisation of impacts. Continuing outside, the 1.8-metre fence will effectively go up to almost 4 metres above our ground level, which is directly outside my son's room. Continuing along, the fence will be in a gully between our home and retaining walls. This is not protecting privacy. To give you specifics, our floor level there is RL 52. The top of the fence directly outside our windows will be RL 54.5. Directly above that, their driveway is RL 55. So they're walking above the fence. Under the DCP control on fencing in flora and fauna conservation areas, vegetation is preferred to any fencing, and there is to be side and rear fences only where necessary. This fence is not. The plans show that planted hedging is extensive. We're concerned about the fire risk of a timber fence, the noise and visual impacts of a metal fence, and the animal holes will be grossly insufficient for wildlife. Last month, my daughter and I shepherded an echidna down our road until it was safe, as it kept coming up against fencing. We are a nature-loving family, and the fence will block our connection with wildlife in a wildlife corridor. 2 of the images used to prove claims that this fence is consistent with others are misleading. 2 are in different zoning. 1 is not legal, which we can prove, and the only valid comparison is just 4 metres long. The rest of this area has either vegetation or low impact fencing, which should be the comparison. The fence will block our airflow, views and sunsets. In conclusion, we request removal of the boundary fence and the following conditions: no new lighting to be permitted to spill into our private open space. Vegetation that currently screens the house that is removed should be reinstated. and the newly installed path to be removed post-construction to bring the landscaping area closer to the minimum requirement. In the report conclusion, it states this development will not result in unreasonable impacts. With respect, it strips us of the parts of our home that give us the most joy.
Any questions? Thank you, Alison, very much. I'm sorry for the interruptions that you had. Any questions or comments from the panel?
None.
Yes, I had a couple through you, Chair.
Thank you.
Thanks for your words, Ms. Hiscox. That's very helpful. Can I just understand, at the rear of the property where your property adjoins theirs, that will continue to have no fencing? Sorry,
Can you say that again? Sorry.
Noise. Yeah, sorry, there's some background noise. At the rear of your property, or the rear of the boundary of your property, so the fencing is proposed for the first sort of 50 to 60%, but the rear of the property, there's currently no fencing between your two properties, is there?
Very low level.
It's like low level. It's low level, and then it turns into a retaining wall. And
Okay,
it's open.
but people can, and that will continue to be
animals
open
can,
as well, won't it?
Yeah, they go through it all the time. Yeah.
Okay, awesome. Thank you for your time.
Thanks.
Thank you. Any further comments or questions?
Yeah,
Then,
I've got one.
Yeah.
Thank you.
That's okay. Thanks, Mrs. Cox. The pathway, I know we've got the plans and there's reference to it in the report, but just so I'm clear, is that the pathway that's sort of behind the parking spaces to the north of the parking spaces? Is all of that the
Yes, it's 33 meters. It goes between our two properties,
right,
and kind of forks. So it kind of splits, goes down and then up.
Yep. And I guess the other question, because I know fencing is raised by yourself and a number of people, I understand that. I guess the response to that usually from proponents usually has to do with privacy and containing pets. So what do you say about that?
So
in response
for
to that
pets,
argument?
that it can't be used as a reason for pets in this area, as I understand. It's fencing. It's a controlled D2.11. Fencing required for the containment of companion animals should be minimised. And what was the other point?
Privacy and
privacy. So we overlook. We look over their backyard in the same way that they look over ours. Like we're on a hill, and the property is so large that we look over them and then they look over us. So the only part that it will afford privacy for them is in an extremely low use area, and where it will be for us is where we are every day as a family.
Yep. Thanks. And you mentioned D2.2.1.1. That was thanks for that. That's useful. I'll check that out.
Yeah, D2.11.
That's the bit that says fencing should be minimised or avoided wherever possible in favour of vegetation. Is that what that says?
Yeah. Vegetate. Right. The word vegetation is preferred to any fencing.
Yep. Okay.
Any further comments or questions?
Yeah.
No?
Yeah. Thanks.
Sorry, who is this?
I think they've just put their it's just their speaker for a different item, I can see.
I'm sorry. So they were the listed objectors. There are also...
Sorry, Chair, we do just have Karen. I can see her. She was on mute previously. If you wanted to just go back to number 7.
I'm sorry, that would be fantastic. I'm sorry. Yes, Karen.
Hello, can you hear me now?
Yes, thank you. We thought we may have lost.
Hi, how are you? Everybody's actually said a lot, which is important, and I agree 100% with what's been said. Being a member of a community with wildlife, like we've got wildlife at our back doorstep, and that, we've got goannas, we've got everything, and I live in Church Point. Now, the main thing is this fence. This fence is going to cut out the privacy of Ali in a way that's not good. Secondly, it's going to cause fences divide habitats. okay? Splitting continuous areas into smaller isolated patches. These hinder natural movement for foraging, breeding and migration, with some studies showing animals changing their routes by up to 40% when they hit a fence. Now, this is important because personally, in this last 3 weeks, I have removed 3 echidnas off McCarrs Creek Road going up the hill. Fortunately, to save them, but they were able to cross. Once they cross, they can move freely. There's no obstacles, stopping them. There may be rocks and things like that, but echidnas move their way around and move. With a fence, this is going to hinder it. It's a breeding season. You can get 10 male echidnas following 1 female echidna. They're classed as a train of echidnas, and to stop this breeding pattern or anything else should be stopped straight away. Not only is the fence hindering wildlife movement, it is also going to cause a huge, beautiful tree to be removed. Now, this is not acceptable. Honestly, we need our trees. We have the glossy black cockatoos here, and we have so much wildlife. Goannas need these trees to breed. A lot of animals need these. Even your tiny little marsupials need these large trees to have hollows in them. And if you plant 10 trees today, they're not going to have hollows. Nothing's going to have hollows. What we've got in Pittwater or North, in the area is something that's been here for a long time, and we're slowly destroying it. Man is destroying every tree, everything. We're getting less and less. Like I lived in Bulgola. We had beautiful koalas at our doorstep. That stopped it, with people putting fences up and everything like that. And pools are one of the main things that wildlife get trapped and die in. And that. Now, every tree is crucial to our environment. This grey ironbark will be criminal to actually remove it. You just look around if you drive along McCarrs Creek, Pittwater Road, and have a look how many houses are looking at you now. All our trees are being destroyed. And why? Because people want to just see views. I bought in this area because, sorry, I bought
One
in
more
this
minute.
area. Okay, thank you. I bought in this area, especially for the vegetation, the wildlife, and everything that nowhere else can we have this other than in McCarrs Creek or Church Point area. Our neighbours, Mona Vale, and that can have fences. They've got small little areas. This is a different area, different scope of land. Do you know what I mean? We got hills, we've got problems with water and everything. So sorry, but I'm more for the wildlife and animals and protection of what we have, and we should value it. Thank you.
Thank you very much. Any questions or comments for Karen?
Ross,
Yes.
just to inform you, might not have noticed, we've got Councillor Causey who's raised a hand in the gallery.
I'm sorry. Yes, please.
Sorry, I'd applied to speak last week. I emailed, so I don't know what's happened with that.
I'm sorry, I didn't have you on the list, but by all means, please, we would welcome your comments.
Oh, thank you. I'll wait till the questions are finished.
I don't think there are any further questions. So if you would like to address the panel, good to have a council representative attending our meeting.
Oh, thank you, and thanks for allowing me to speak. So I'm a Pittwater Ward councillor on Northern Beaches Council, and I rarely address the panel, but I'm here because residents have asked me to, and that includes a number of residents who can't be here today because of work commitments or other commitments. The various iterations of this proposal have caused significant community distress, as can be seen from the, I think, more than 50 submissions from individuals and community groups. Church Point sits right next to a national park, and residents live there because of the nature that they want to be immersed in. Many are distressed to, sorry? Sorry?
Sorry, could that person please desist from interrupting? So if you,
Councillor Paul, talking. Hang on a sec.
I'll try and mute them, Chair. One moment.
if you would, please. Is it the same person that's been interrupting us previously?
Yeah, I don't
Well,
think they
if-
realise they're not muted. There we go.
I'm sorry, thank you. Yes,
So Church
if
Point
you could
sits next to
continue,
the.
please.
Okay. So many are distressed to see the bush they cherish threatened and destroyed. And I get complaints literally every week, and often multiple times a week, about tree loss in Pittwater, either through developments or proposed developments. Trees are not ornaments, or not purely ornaments, as the Arborist report would seem to suggest. Amongst other things, they are critical to wildlife, as we've heard, and the removal of 17 trees would have a substantial impact on habitat and food sources, as other speakers have suggested. And it takes something like 100 years for a tree to actually develop a hollow where wildlife can live, and often longer than that. There's also significant concern about overdevelopment, as we've heard. Approval of this DA would set a precedent, making it easier for future proposals to push heights, fences, bulk and form well beyond limits that are acceptable to the local community. One of the outcomes intended in the Pittwater DCP's minimum landscaping requirement is to promote a scale and density in proportion to the height of the natural environment. This application justifies non-compliance with the minimum landscape area by stating the proposed swimming pool and cabana are sited close to existing ground level and sit well below the height of the natural environment. Now, we've heard about this from Ms Hiscock already. However, there is a height difference of 2 to 3 metres above natural ground level for a large part of the structure. So this outcome would not be met, and then a pool fence would sit above that. Furthermore, the current building is already about 12 metres above natural ground level, which is above the 8.5 metre height limit of the area. And due to the steepness of the hill, that extra height already accentuates the visual bulk of the property for neighbours and from the waterway. Replacing hard surfaces on the other side of the property to those in the C4 zoning doesn't compensate those smaller properties for that increased bulk and overshadowing. I also note the owner recently built a concrete path more than 2 metres wide and 30 metres long along the boundary with their neighbour at 18 Quarter Sessions Road. I believe it has not been approved and is non-compliant. Neither is it included in the hard surface calculations for the proposed changes. I'm also concerned about the proposed wooden fence. That's already been discussed. Having actually experienced the 1994 bushfires, I'm worried that the timber eaves of one of the neighbours are less than 1 metre from the proposed extensive fence. And this is at odds with the RFS's referral and safety requirements. So in conclusion, I believe this DA should not be passed. Just one other thing I'd like to mention, that's just gone out of my head. Yeah, actually, the idea of council actually supervising replanting trees and all this sort of thing, it does not happen because the council does not have the staff to do it. And I get complaints about this. Again, it's probably practically every week, certainly very, very frequently. So, once we lose these trees, they've gone, and it will take 100 to, 200 years to replace them, replace the canopy, and the wildlife by that point will be well and truly gone. So thanks very much, and yeah, thanks for allowing me to speak.
Thanks, Miranda. Any comments from the panel? Or
yes, I have one, Chair. Councillor, are you aware of the latest proposal? Because there have been a couple of proposals, and the latest one, as I understand it, is only calling for the removal of 3, and they're called by council relatively insignificant trees. Certainly not 17. That's not my understanding. Could you clarify that, please? Have you seen the latest proposal?
I think the councillor has left the meeting.
Oh, okay.
Sorry, Phil.
I had similar questions actually. Thank you, Phil. Anyway, if there are no further questions or comments from objectors, we, I believe, have representatives of the applicant or the actual owner. Lauren, who do we have present?
Yes, so we have Tim Osborne, the owner. We have Sebastian, and then we've also got Sean Wright, I believe.
Thank you. So initially, could we hear from the owner, Tim Osborne, please?
Thanks, Ross. Is my audio clear?
Yes, very.
Yes.
Thank you.
Great. Look, as the applicants, we recognise the importance of community participation in the planning process. We are not town planners or landscape architects, so we'll refrain from commenting on these matters. However, several submissions made in relation to this development application contain statements, in our opinion, that are demonstrably false, misleading, or speculative. We believe it is important to clarify the record to ensure that the panel's assessment is based on verified factual information rather than misinformation. Across 2 exhibition periods, a total of 51 submissions were received, and an additional further 2 late submissions on the 13th of October, a higher than usual number for a proposal of this scale. On review, a substantial proportion of these appear to originate or be influenced by the adjoining property at number 18 Quarter Sessions Road. A significant number of submissions replicate identical or near identical text, evidencing a deliberate and coordinated campaign designed to manufacture opposition rather than reflect authentic or independently considered views. Of the 6 immediately adjoining properties, only number 18 Quarter Sessions lodged an objection. All other immediately adjoining residents to our property have indicated their support for the proposal directly to us. Unfortunately, in our opinion, some submissions extend beyond legitimate planning comment. They include inaccurate, malicious, unsubstantiated allegations, personal assertions, and statements of a defamatory, slanderous, or derogatory nature made without any evidentiary basis. These remarks fall outside the scope of the council planning and assessment framework and risk unfairly prejudicing an otherwise merit-based application. As the applicant, we have deliberately refrained from engaging in retaliatory commentary. Our focus from the outset has been solely on ensuring the integrity of this assessment. We trust that council and this panel will assess our proposal and its planning merits as a compliant, environmentally responsible and contextually appropriate improvement to our property. Our focus remains on enhancing local amenity, protecting ecological values and contributing positively to the character of the area. For the avoidance of doubt, we wish to make clear that the deliberate dissemination of false or defamatory material, particularly through digital platforms or council's online submission system, may constitute publication under the New South Wales Defamation Act 2005 and may also engage the provisions of the Commonwealth Criminal Code Act 1995 relating to the misuse of a carriage service to menace, harass or cause offence. We reserve all legal rights and remedies in relation to such conduct and will not hesitate to pursue any necessary action to protect our reputation and characters. We regard any continued publication, repetition, or distribution of false or defamatory material, whether by written submission, verbal, online publication, or other electronic communication, as actionable under New South Wales law. We would also encourage all parties to make sure that submissions currently published online are factually accurate, evidence-based, and made in good faith, so the public record remains transparent and the assessment process fair for all involved. I'd like to thank you for your time and consideration on our application at 20 Quarter Sessions Road. Thank you.
Panel, any comments, or shall we hear from the other consultants for the project and then there may be further questions?
I had, just through you, Chair, I did have a couple of questions just regarding the fence and I think a question around domestic animals and pets, if that's all right.
By all means.
Thanks for your time, Mr. Osborne. It was my understanding that part of the reason for the fence that covers about 50 to 60% of your boundary with number 18 was driven by the need to ensure that domesticated animals stay within the property. Is that correct?
It wasn't the driving factor, but it is one of the purposes of the fence.
And so is there a reason it needs to be a fully enclosed, or not enclosed, but fully formed wooden fence as opposed to something that might have openings within it or retaining just the vegetation?
The design aspect I'll leave to our consultants, if that's okay.
Sure.
Okay.
Yeah, not a problem.
I'm not a design guru.
I totally understand. So I guess then the question is, if the panel were to consider, because obviously the fence has been one of the key objections raised at this meeting, if the panel was to consider a condition where possibly it was a more open fence or went back to something like vegetation, is that something that you have a fundamental objection to, or would you rather we ask that question of your design consultants?
Look, we definitely need a fence. We do have domestic dogs, yes. And I think, as I said, we didn't want to get into retaliation. One of the comments was from the submissions that our dogs roam the entire Church Point area and cause destruction and harm, which is not the case.
I didn't know that part of it at all. It's more around, and as a dog owner myself, because the fence doesn't obviously cover the entirety of your property boundaries, what does that component of the fence do to help restrict the dogs, whereby they could technically go onto other properties if they just went down to the end of the backyard?
If we just left vegetation between the two properties, they can potentially get out onto the street and be run over.
Right, so it's more about protecting them from coming out to get onto the street.
Exactly, yeah. So there's a safety concern there. The street's dangerous enough as it is with what goes on currently.
Okay, and we might ask the question around design of your design consultant.
Sure.
Thanks very much.
Sorry, to comment on that, please, or just a further question, Mr. Osman. Could it be that there is a lesser area which is fenced for your pets?
I don't think it could be any less than what's...
An alternate fence configuration, which perhaps addresses some of the issues raised by the community and the presentations today.
If there's a design option, I'd leave that to our design consultants, yeah.
I mean, obviously, the pool needs to have adequate and compliant fencing, but that may or may not.
Obviously, yeah.
Yeah, but there may well be an alternate solution for the fencing generally, other than the pool fencing.
Potentially, like I said, I'll defer that to our design consultants.
Thank you. Thank you. Anything further?
I've got a follow-up. Yeah, I've got a follow-up question. So, Mr. Osborne, do I understand you're saying before that in response to concerns that your animals were wandering the locality, that's not the case? That's what you said?
They weren't wandering the locality, no.
Right, so they're contained within the property.
They are contained within the property.
So if that's managed to be done without a fence at the moment, why do you need a fence to contain the animals?
As I said to Kate Bartlett, the sole purpose of the fence was not purely just to keep the dogs in. There is a privacy aspect that we want to improve.
That's more important than the dog containment aspect, or?
It is to us, yes. Well, after some of the slanderous submissions over the last 6 months, yes.
Yeah. Look, I know these DAs from both applicants and objectors can be, I'm not sure what the word is, but emotional, charged, people's homes are involved. But look, you're living in a community, and all I'd say, what I'm hearing from people who are speaking today, it's unusual, I've got to say, for 8 people to address it. Usually if you're, manufacturing objections, like you said, it'd be unusual for this number of people to take the time out to address a panel. That's hard to manufacture. And what I'm hearing is probably some passion for the attributes for the area and its, its natural state. So I just encourage you to try and understand what's behind, people's objections that they're allowed to make. I totally hear and understand your concerns about any libelous comments that you're alleging. I've got no view on that. It's a matter for you, but I guess behind it, what I'm hearing and reading is concerns about environmental protection.
Yep.
Anyway, wasn't a question.
Tim, I'm a bit. My name's Phil Young. Hi. I'm a bit confused about how you are restraining the animals at the moment. I know that's not part of what we're deliberating today, but how are they retained within an environment, within your environment at the moment?
Unfortunately, within the internal building footprint.
So so the animal, the dogs, you're talking about dogs. You've got more than one by the sound of it. They have to exist in your house. Is that what you're saying?
For 95% of the time, yeah.
And you haven't considered having an area outside that is suitable for them, but not as large as the fence that you've has been proposed?
Look, we've looked at a number of options from electronic collars, et cetera, and they haven't worked. And as mentioned in a number of submissions, we feel that as soon as the dogs leave the household, we're under constant and continual scrutiny when they're on our property. So we're hamstrung at the moment.
Yeah, sorry, I might have miscommunicated. I'm a bit confused because, for instance, next door to me, they have a dog. We have open fences in this environment here, and they have a small area of grass where their dog can run around and be when they're not there, and so on and so forth. But I suppose that would consist of less than a fifth of their backyard. It's an area big enough for the dog to feel happy in a natural environment. Are you open to that sort of thinking, or?
I think that type of what sounds like a pen arrangement probably wouldn't work on the topography of our land. If it was a nice flat block of land, then yes, you could pen the dogs in and convert the backyard into paddocks and shift them around, et cetera. But I don't think that would be an appropriate solution, just to have a small little pen on a sloping block of land in our backyard as it currently stands.
Okay. And I guess I've had one other last question, and that is the fence that's proposed doesn't seem to allow for significant wildlife movement. There are other solutions which have been mentioned earlier today, but those would not allow wallabies, for example, which I understand you have on your property and adjoining properties, to move inside your property and out and so on. Is that correct?
In the coming up to 2 years of ownership of this property, we have not seen one wallaby within number 20 Quarter Sessions Road, within the boundary of 20 Quarter Sessions Road. So I'm not sure how they would traverse between us, as you've just mentioned, Phil.
Well, your neighbours, well, I must admit I don't live there, so I don't know. But I'm under the impression from the wildlife information we've received that there are wallabies in the area, even though you might not have seen them.
There is wallabies in the area, yes, absolutely.
Okay. All right, thank you.
They don't traverse between the two properties, between 18 and 20 Quarter Sessions Road.
Okay,
Tim, perhaps we could, and Tim, thank you for your comments, but perhaps we could ask some of the similar questions to your consultants, if they're able to. One of them, there are two listed, which may or may mean one of them could actually speak on behalf of their involvement. So if we could move to that and perhaps if need be, come back to Mr. Osmond later. So either Sean or Sebastian, I'm not sure which one of you would like to address the panel.
Sean will put his hand up. Can you hear me? I am remote, so I apologise if the sound is not good.
Sean, thank you. You've heard the presentations from the community and from residents and the questions so far to the panel. Would you like to address the panel, and then perhaps there are a few questions we may direct to you?
Please. Thank you for your time, first and foremost, to the panel. Couple of items initially. The councillor mentioned the removal of 17 trees. Thank you, Phil, picked up that's not the case. The initial iteration had a large number of trees proposed to be removed. That has changed to 2. One being a camellia and one being a deceased eucalypt that is dangerous. So we've worked very hard to work with the natural environment to ensure that the impacts of this proposed development are minimal. I live in a locality. I understand the beauty of it. I want my kids who live there to enjoy the harmony of the environment going forward in their lives. So by no means would me personally, or as a business working with people within the area, want to do or undertake development that puts any of this at risk. That's a general comment as an overall perspective. I would, contrary to a lot of the objectors' comments in writing and today verbally, there has been extensive consultation through the experts that were engaged from an ecological, from an arboricultural, from a planning perspective, in deep consultation. And I give great thanks to Council for allowing open communication, working together to get a better outcome for the locality, in conjunction with the desires for the property owner to increase amenity and lifestyle within their property. So that's my main comments in regards to that. The fencing, there was a comment previously about this timber fence that's high on the list here. We're not relying on the boundary fencing for any pool fencing. The boundary fencing, as Tim mentioned, has a number of factors, and hence why it was designed is privacy, amenity, privacy being acoustic and visual privacy, and retention and security of domestic animals. We discussed a lot of things initially in the process about the environment and things like wallabies, and we would have acted differently if we thought there was some great effect on them. But as Tim mentioned, in the time that he's been there, and I actually consulted with the previous owners about some other development that they were going to undertake prior to the sale. And this was discussed, and they'd been there a number of years. And so the wildlife and impacts on them didn't come up as anything that was going to be negatively impacted. So that's probably my say. I'm happy to answer any questions on the back of that.
Panel, any questions of Sean?
Just the same question I asked of Mr. Osborne. Thank you, Mr. Wright. Is there a design that could have the fences somewhat more open that still enables the dogs to be protected from running across the property and out onto the road?
For what benefit, may I ask?
Well, I think it's the balance. I mean,
Yes.
I hear what you're saying, but there are a number of other speakers today who have talked about the ability of wildlife to move through the property and around properties. And so, and then also I think the neighbour also noting that the fence height doesn't totally protect in terms of visual privacy anyway because of the fall of the land. So is there a design of the fence? If we're talking about the fence primarily being to ensure that the dogs don't run across the neighbour's property and out onto the road and get injured, is there a fence design that could have more openings to enable particularly smaller wildlife to move throughout that would still give that protection for the animals?
I think in answer, yes, there could definitely be a fence design that could be more, that could assist the animals. I do take note of earlier comments in regards to the length and size of the property and the rest of the property, you know, I don't know a percentage that has the ability for animals to cross. So I don't really see how a small proportion of a solid fencing is going to completely cease any animal movement. But in short, yes, there could be some minor adjustments made to the fencing for animal movement in light of still containing the owner's domestic animals. So yes.
Thank you.
I've got a follow-up question through you, Chair, if that's all right.
Yes, by all means.
So you're a landscape architect?
Well,
Right?
designer.
Okay.
Yep.
So let's just work on the assumption that the planning controls do state that landscaping is preferred to hard fencing along the boundary. Do you think, as a landscape architect or landscape designer, there's a landscape solution instead of a fence to give effect to that control, assuming it applies?
Not in the sense, and I've dealt with this a lot, and I've done a lot of land environment court work as well. And in many cases, I personally across Sydney have tried to argue the usage of vegetation as a barrier for privacy, visual and oral, and security. But it doesn't work, because the answer a lot of council comes back is, well, what if a tree dies? What if a shrubs, you know, what if a shrubs suffers from insects and pests? Then that visual barrier disappears. So I think the 1.8 high fence will provide that visual, the visual and oral privacy and security, coupled with a hedge that can grow higher than the fence. So we get a double barrier, if you like, in terms of a boundary treatment for the subject property.
Right. But are you saying in those court cases you're usually advocating for the effectiveness of landscaping as fencing, but the response you usually get is that there's dieback?
It is more that I should clarify, that's more vegetation in control and softening of the built form. Whereas in this instance here, the boundary fencing is not, or any hedging along the boundary, is more a visual, a soft perimeter planting for the subject property, and the fencing for privacy and containment of animals, as has been discussed.
Thank you.
Thank you. Sorry, any further questions? No? Just Sean, just a question. I guess to me, it seems to be emerging that there are three requirements in terms of fencing. One is some delineation of boundary. The second is for pet security, that obviously is desirable and required for the pet/dogs, and then for the pool. They represent to me potentially the opportunity for different solutions that may give an overall outcome which addresses some of the concerns and issues that were raised by some of the presentations earlier. And I guess I would be interested in your comments on if that is something that's possible. I mean, I noticed that there is already nothing being proposed for the front of the building, the driveways, but generally, I guess the resolution of those three principles or three issues is a challenge for design. But that's the whole reason why potentially your involvement is happening. And so, I mean, I would be interested in your comment, and perhaps even Tim, if you would care to comment on it, because to me it would seem that's a possibility that may lead to an outcome that satisfies your requirements, but maybe also the community.
You made 3 points, one being the pool. As I mentioned before, the boundary fencing is not being utilised in this instance as a pool barrier. The pool barrier will be in close proximity to the residents and adjacent to the swimming pool. Yes, as I mentioned before, in regards to wildlife, there would definitely be some further detailing that could be undertaken to look at the fencing type and construction method to maintain, protect, whatever it might be in terms of the wildlife. I suppose the fencing location and extent, I would defer back to Tim in some instances in regards to its location and extent, because it's his property and he will be living there a long time, and it's going to, the amenity that that fence will provide will benefit him and hopefully the neighbours adjacent. So there potentially could be some adjustment there, yes, subject to further consultation, I would imagine.
Thank you. Tim, do you wish to comment briefly on what we've been talking about?
No, I don't need to add anything else, Ross. Thank you. Thank
you. Panel, any other comments?
Yeah, I've got one more, and sorry I didn't raise it earlier, but the pathway. I guess there's two ways of thinking or looking at that. One is that, as in the report, it's a separate compliance matter. It's not part of this proposal. The other perspective might be that the DA is non-compliant, the landscaped area, that path adds to the non-landscaped area, and there is some link between the two. So is it proposed to remove that pathway, and what's happening with that compliance action? I'm just asking you if it's what's your response to the argument that there is a link between an unauthorised path and the DA because of the non-compliance with the landscaped area? And I guess what's the status of that issue?
Well, I can comment. Council are well aware of this path from the get-go. It was picked up on the survey. It was always counted within our landscaped area calculations for the development. So it was considered. The intent is for it to be retained for amenity purposes of vegetation removal and access to the rear of the property, because this is the primary access for the residents. So in short, it's been integrated, considered, and assessed from the get-go, and therefore our understanding is supported by council as part of the overall proposal.
So your understanding is DA is approving that path, is it?
Well, my understanding with the path would be exempt development.
Right.
But it has been included in this proposal because prior to our documentation being undertaken, it was present and therefore picked up and captured within this topographical survey of the property for submission and the subsequent landscaped area calculations that followed.
Okay. Jason, anything further? Then I thank all of the people who have made submissions and the applicant and his consultants. Obviously, this is a very sensitive issue that the panel will contemplate and discuss further in the closed session. Hopefully, we will be able to make some resolution and determination which should be available within the next 24 to 48 hours. But thank you all for the time and effort that's been put into this for this meeting today. Thank you.
Thank you.
Thank you.
So do we want to have a break for a second, or we'll just continue with? I'm happy to continue. So let's move to the next item. Item 4.2 is 16 Wyatt Avenue, Belrose. I have some people who wish to address the panel. There is Mr. Patton, if he is available.
Yes, I'm here. Can you hear
Thank
me?
you. We can. Thank you, Mr. Patton. If you would like to address the panel, please. As you may have determined, there is a 3-minute presentation period plus a minute to sum up, if that would be something you could try and comply with.
Yes, thank you. My name's Ron Patton. I live with my wife in Wyatt Avenue, diagonally opposite the subject site. I'm speaking on behalf of the Belrose Rural Community Association, my wife and myself. This modification is for one of the 2 approved boarding houses on number 16 Wyatt Avenue, Belrose. This modification has various proposals
including the provision of cooking facilities in each room in one of the boarding houses. The original approval for this development was granted by the Land Environment Court, and notably, it excluded cooking facilities in individual rooms. Boarding rooms without cooking facilities was a key factor in the court's decision, ensuring that each room could not be classified as a self-contained dwelling. To be clear, the initial application included cooking facilities. However, during the court's proceedings, these facilities were removed to comply with the planning controls for housing density. If the cooking facilities are introduced now, each room would become a self-contained dwelling, thus violating the density controls under this locality's C8 in WLEP 2000, which is 1 dwelling per 20 hectares. This is a non-urban area. Approval of this modification would set a concerning precedent, not only for the second court-approved boarding house on number 16 White Avenue, but also for a third boarding house already approved on the adjoining property at number 14 White Avenue, which has the same owner as number 16 White Avenue. These 3 boarding houses have a total of 80 rooms. With cooking facilities, they would vastly exceed the density limits of the locality. The applicant states that there are no physical changes to the rooms. However, we understand that if cooking facilities are provided, then it is essential to have appropriate ventilation. The modification application does not refer to ventilation, nor does the current assessment report, which is before the panel today. This physical change will mean that the modification is not substantially the same as the approved development application, and therefore this proposal would require a new development application. It's worthwhile noting that boarding houses with cooking facilities are often marketed as executive studio apartments, commanding significant higher rents. This undermines the original intent of the development to provide affordable housing as stated in the initial application. The approved boarding houses offer minimal on-site parking, creating self-contained rooms would only exacerbate the on-street parking, with executive studios attracting more people with cars, and this would impact the quality of life for the current residents on White Avenue. In looking at the court's decision, where it was a key part of their approval, consent condition 3 Part B states, in order that each of the boarding rooms and a manager's residence are not capable of being used as self-contained dwellings, each of the boarding rooms and the manager's residence must not contain or at any time have installed any cooking or meal preparation facilities. This includes plug-in electrical appliances. All meals must be prepared in the communal kitchens provided separately within the premises. This condition was a cornerstone of the court's approval. The current assessment report before the panel downplays this critical aspect of the judgment. We strongly urge the panel to refuse the proposed modification. Approval of this modification would undermine the condition imposed by the Land Environment Court, alter the nature of the development, exceed the planning controls, and it would set a precedent for future intensification of this site and the adjoining property. We thank you for considering our presentation. This objection reflects the concerns of numerous residents and the members of the Belrose Rural Community Association, who are committed to preserving the character and livability of our area. We trust the panel will prioritise the integrity of the original court's decision. Thank you.
Thank you very much. Any questions from the panel?
Yeah, I've got a brief one. So, Mr. Patton, the proposal, as I understand it, is to allow for microwave ovens. I think the assessment report, as I'm reading it, is providing some differentiation of that being a cooking facility as opposed to a reheating sort of facility, and therefore the council staff are happy with that. So it's your view that a microwave oven is a cooking facility and allows the full self-containment of those rooms? Is that your view?
Definitely. And when you read that consent condition, it states that it's to exclude, this includes plug-in electrical appliances, and a microwave is a plug-in electrical appliance, and even some microwaves have convection oven abilities as well. And so it's in contrary to this court's decision.
Okay, thank you.
Any further comments or questions? No. Mr. Pratton, thank you very much for your time, and I'll ask if the applicant wishes to address the panel. Mr. Holman?
Yes, can you hear me? It's Mr. Holman here.
Mr. Holman, thank you. If, as you perhaps determined, 3 minutes and then a minute to sum up, and I'd be interested if you could please comment on the statements that have been made by Mr. Patton.
Certainly. All right, thank you. My name is John Holman. I'm the applicant for that modification in question. I'm an owner, along with my wife, of the properties at 14 and 16 Wyatt Avenue, Belrose, both of which have DAs approved for boarding houses on them. We've lived on the property since purchasing it in 2001. I'm currently overseas and I'm presenting to the panel at 4 o'clock in the morning, mainly to make myself available to answer any questions that the panel may have. I agree with the council's assessment report that the DA mod should be approved. However, I disagree with the conditions of consent proposed. The DA mod has lodged requested changes to the conditions of consent to make them consistent with current legislative requirements and not restrict the ability to install an on-site wastewater system. So the changes that are sought to the conditions of consent are administrative only, and they will allow me to install an on-site wastewater system, which is the subject of separate approval. So the DA does not include the on-site wastewater system. That is the subject of a separate approval process that has its own conditions of consent attached once it goes through. A construction certificate is an approval required before building work can be carried out. It ensures the plans are complied with and the development consent and technical regulations like the Building Code of Australia are adhered to. And it's the installation of a pump to sewer system is not building work, that's actually works which are ancillary to that development. I provided details on each of the individual proposed amendments in the conditions of consent in my submission to the panel, and I'd like to make myself available for any questions on the panel. You did ask me to make a comment on Ron's Ron addressing the panel. The housing density of 1 house per 20 hectares has effectively been abandoned. This fact is on record with council for the boarding house located at 2506 Bundley Street, Belrose. It's in the same locality as we're in. There's a letter from the Department of Planning saying effectively the 1 house per 20 acres has been abandoned. So I don't think the housing density has any status. So that's probably my outline to Ron. I think Ron's legal opinion on things is probably of limited value. I think it's important for council to get their own legal advice on things. So I'd open myself up for questioning.
Panel, any questions to Mr. Holman?
Yes, I had a question. Sorry, Mr. Holman, just to clarify. So what you're saying is the wastewater system is a subject of its own development application and you didn't include it as part of this application?
No, Kate, it's a separate approval process. So it's one through the Local Government Act, not through the Land and Environment situation. So it is a separate application. There is an application into council, as I've outlined in my submission. So it is a completely separate application process. I've actually gone through this before on another property that I own. So they always keep the processing of sewer separate to the DA because it is under the Local Government Act. It's not under the EP&A Act.
And your concern is that some of the conditions on the proposed consent conflict with the approval that you're seeking under the Local Government Act?
And yes, I'm concerned that they are administratively not totally correct ranging from grammatical errors to just trying to get the process correct. I don't believe that any of the modifications that I've asked for are actually in conflict with what is required on the project. I think it's important to try and nail things down administratively so it is all correct.
Okay, thank you for that.
Any further questions of Mr. Holman?
Yeah, I've got a question.
Yes.
So, Mr. Holman, what I'm reading is one of the main things being sought is the microwave oven in the rooms. Is that right? Is that what's proposed, or is other non-fixed cooking facilities
No,
proposed?
sorry, Jason, it is just a microwave oven in the rooms, and it's only in the bottom buildings, not on the top buildings. It's just to give a bit of diversity of what's available within the approved development. Right.
And the wording that we have from the council staff about the amended condition says that, or the change recommended by council staff is to say that blah, 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 each of the boarding rooms and manager's residence must not contain or at any time have installed any fixed cooking or meal preparation facilities. So I guess I've got a bit of a concern with that recommended wording, because you could read that to mean so long as it's not fixed cooking facilities, then you can have them. So would there be any concern, speaking to you, and you're reiterating your point about the need for clarity and preciseness, would there be any concern for you with actually using the specific words about microwave ovens, or just a reheating microwave oven, given they can be convection ovens and air fryers and all sorts of things now? Is there any concern you'd have with specific wording referring to a microwave oven for heating or reheating?
No, I wouldn't have any concerns at all. No. I mean, there's two ways to approve it, the way that's been suggested, or to just approve it as per I've suggested in my draft conditions of consent, because the boarding house that's also in the same locality as I'm in has been approved for full cooking facilities within the site. The whole boarding house, every single unit has cooking facilities. It's been approved by council through the Land and Environment Court process. So I don't think whether they are or they aren't dwellings is really that relevant, but I'm happy with the proposed wording, and I'm happy for that wording to also include that it's microwave ovens, if that helps the panel.
Thank you.
Thank you. Any further comments or questions of Mr. Holman? If not, thank you, Mr. Holman, and also Mr. Patton, for your presentations today. This will be referred for further consideration later this afternoon, by the panel in the closed session, and a determination will hopefully be made that will be published in the next 24 to 48 hours. So again, thank you for your time and thank you for your contribution.
Thank you.
Okay, that's item 4.2. Can we then please move to item 4.3, which is 3 Lauderdale Avenue in Fairlight, which is a DA for a residential flat building. And just check, we have a request for presentations from an objector. Is Andrew Agnew available, please?
Yes, Chairman. Can you hear me?
We can clearly. Just 1 second while I get my paperwork sorted out. Thank you. So, yes, Mr. Agnew, would you like to address the panel, please? 3 minutes plus a warning and a minute to sum up. Thank you.
Thank you, Chairman. I've sought legal advice from Apex Planning and Environmental Law, who are a specialist local government firm of solicitors regarding the proposed stormwater disposal from this site. I hope that the committee has had a chance, the panel has had a chance to read it. It's on the public website already of the council, and it should have been distributed to the panel prior to this meeting. My wife owns 3A Lauderdale Avenue, and I live here with her. Our property is immediately to the west of the development site. Our solicitor's advice is very clear. The panel cannot approve the DA in its current form. The easement which runs along the eastern boundary of our property contains a pipe over which the development site has no lawful authority to use. The council's authority to use the pipe is for the purpose of draining water from Lauderdale Avenue. The council is not the owner of the easement and has no legal power to approve the proposed connection to the pipe by the developer, unless my wife gives her consent. My wife has not given the developer written permission to enter our property to connect their stormwater to the pipe in the easement, nor has my wife given written consent to the making of the development application. Such consent is required because the connection to the pipe requires entry to and works on our property. The suggestion in the council report that the council can grant a Section 68 approval to the developer is wrong. A Section 68 application can only be made with the consent of the owner of the land to which it applies. My wife has not given such a consent. In order for the consent to be granted to the DA, the panel must be satisfied by the requirements of the clause 6.21 of the Manly LEP that arrangements have been made for the provision of essential services before the consent is granted. For the reasons contained in our solicitor's advice, no such arrangements have been lawfully made. As proposed within our solicitor's advice, there is a simple solution to this issue that my wife and I have raised. That is, the developer should redesign the required stormwater disposal system from their property to direct stormwater through the rear boundary of the property site, of the development site, and connect directly to the council stormwater system within the public reserve. In other recent and proposed developments around Fairlight Beach and the public reserve have or will connect directly to the council stormwater system in the public reserve. This approach would avoid any disturbance to our property and any potential damage to the boundary fence on our property. Thank you for your considerations.
Mr. Agnew, thank you. Any questions from the panel or any comments? No, the applicant is not present today, I understand, or has no request.
They didn't make a
So-
request, but I can see them in the lobby.
I did make a request to the planner yesterday, but it sounds like it hasn't got through. So
I'm sorry, could we have your name, sir?
my name's Mark Baxter. I'm the architect for the proposal.
So, I mean, I'm happy as chairman to allow you the usual 3 minutes plus a minute to sum up if you would like to address particularly the comments made by Mr. Agnew. And then we may have questions.
Thank you, Mr. Bondford.
Yep, we may have questions for you.
Sure. May I just say that overall we're supportive of the recommendation. The recommendation includes the option to leave the stormwater into the adjoining easement. There's a little bit of history with this. We've had 3 or 4 consultation meetings with the Agnews next door in good faith. We made lots of changes to our design to meet their requirements. The one thing we requested is that they consider allowing us to tap into the stormwater easement, which adjoins the boundary. We received an email from them, and I'll read out from it if I can, that in the 10th of February, where they said, "We now encourage you to formally submit your DA, including detailed stormwater plans prepared by a qualified hydraulic engineer, clearly outlining the proposed system for council's assessment and approval. Once your application is lodged, we will now review it thoroughly and in good faith." Read that again, thoroughly and in good faith. So we did provide the detailed stormwater plans to the Agnews. We also provided on the 14th of the 4th this year a methodology statement of how we would drill through the wall and also tap into the stormwater pit, which is on their site, on the easement. And we also provided a detailed report by our structural engineer on the 3rd of April as to how it would not damage the new wall which is there. That wall is a dinsel wall which is bedded down into the rock. It was built by the architects for the applicant, I think 15 years ago, Andrew, and it's structurally sound. There's no way that it's going to be damaged by drilling a hole through it. I guess in terms of the process, our hydraulic engineer, civil engineer, we discussed the options going through the easement, directly to the easement, or through the council reserve. And they spoke to the council's hydraulic engineer, and they were adamant that the only option was to go through the easement. The easement, I believe, is owned by council. I don't understand why Andrew says it's not owned by council. My understanding is that it's a council-owned easement, and yes, it does drain the water from not just Lauderdale Avenue, but all the way up Wood Street. There's quite a large catchment area. The additional load from our site is insignificant compared with what is already draining through the site. We received detailed plans from the architect of Andrew's property at the beginning of our project, which showed where the stormwater line is. It's only about 300 or 400 mil below the surface. There should be a lid on that pit which we're connecting to, and I understand the Agnews have landscaped over that pit with some paving and some landscaping elements that can easily be moved. So from our perspective, there's no permanent damage, and we were a bit puzzled as to why they're not willing to look at the information we've given them and consider that as an option. Certainly, we don't want to cause any damage or danger to the situation, but we don't believe that the Agnews have gone through that process. Council then advises that I think Danielle, Andrew's wife, wrote a subsequent letter saying she doesn't give approval for us to use that pit, and I think council then had to amend their report to say that we needed to get a Section 68 application, but they assured us that there would be no impediment to approving the DA as it is. So we'd ask that you follow through with the recommendation by the planners, which is to approve the DA, but that we're required to undertake a separate application of Section 68 for the stormwater. I would say the complication with going into the reserve is that there's two property holders there. I think one's part's Crown land and the other is the reserve. And my advice is that it's a notoriously difficult and slow process to get both those approval, which is one of the leading reasons why we didn't push council to let us go through there in the first place. So that's probably as much as I can advise my understanding of the situation.
Thank you.
Thank you.
Any comments or questions from the panel? No, there are none. I would ask if Mr. Agnew could come back online, please.
I'm online, Chair.
Thank you very much. Andrew, I'd be interested if you wouldn't mind just briefly having some comment from what we've just heard from the architect.
I don't really know where to start because his interpretation of events and facts are somewhat different to my recollection. Since January this year, and there's no need to drag the panel through it all, I will just make a few comments. Firstly, that I rely on my solicitor's comments as to the law on this matter, and I think the letter that he has provided, which the panel has, is relatively straightforward and clear on the law. With regards to the obligations that we have and the damage to our property, it's quite clear that there will be damage. We are also concerned that council is already spending a lot of great taxpayers' money trying to resolve the flooding on our property and our next door's property, and to suggest that our pipe can take extra capacity is somewhat ignoring that it's already flooding. we've already got overcapacity problems. For the council to then spend ratepayers' money this year to try and amend that issue, and then for the council to turn around and approve adding more water, just doesn't make logical sense to us. Where are we left with our continual flooding problem? That is the advice that the DA has is incomplete on that matter. However, despite the facts of the matter, I think that our legal advice is relatively clear on the matter, and that why should this particular property get any exception to what every other property is required, that is to direct their stormwater into the, as we all have, into the council's stormwater drain at the back, at the rear of our properties. Don't see why they should get an exception to that.
Andrew, thank you. And I just, in order to make this a little bit easier for us, Mr. Baxter, do you have any comments further than what we've just heard?
Look, if I can just make one comment, I don't know the details of the flooding that Andrew's referring to on his property, but I understand it's due
council
to the,
has
well, can I just
has
finish,
its
Andrew?
worksheets.
Sorry, Andrew, one at a time, please. Yes, Mark.
I understand it's to do with water running down Lauderdale Avenue and jumping the curb and jumping over their driveway boundary easement. So I would suggest that it's due to that not being high enough. It's not due to excessive water going through the actual easement pipe. And the amount of water, the calculations that our stormwater engineer have done show the additional water from our site is incredibly insignificant compared with what's coming down. And the stormwater pipe itself is adequately managing. There may be surface overflow, runoff, maybe to do with your ground levels, Andrew, but that's not to do with the capacity of the pipe.
Okay, Andrew, I'm sorry to cut you off, but we can have one speaker at a time, please. Just very
you are correct, Chair.
Sorry, so very briefly, just a quick answer or response.
When the flooding occurs, the pipe is completely full and is flowing out into our property from the pipe at its point of inspections. To suggest, therefore, we can add more water to the existing pipe rather than is incorrect.
Final question, Mark. So if you were required to connect into via the council reserve as opposed to what's proposed, what are the consequences you see?
Well, the consequences are it will delay our project at least 6 months. It may make it unviable because my client is an owner developer. She doesn't have the sort of money that she has a financial impediment to purchase a part of the land from his sister. Putting it bluntly, it may just mean the site gets sold to a developer and we'll end up with something like number 5, the other side, as a scheme. So I just don't, we went ahead in good faith with the understanding this would be the right way to go. We provided all the information that Andrew's required. I don't have any data. I've never heard that pipe backflows through the pits on his side. If it did, it would come onto our side. But I'm not privy to the detailed council documents. You'd have to speak to council engineers. There's 2 pits on the easement, the stormwater pipe easement that adjoin our boundary. One they've covered over entirely down the bottom, which is the one we're tapping into, and there's one further up. But Andrew has never indicated that backfloods through that pit. So I'm not sure whether, but I don't have the detail that I guess council's stormwater engineer would have to be able to advise on the details of the flooding.
Okay, thank you both, and the committee or the panel will obviously meet a little later today in the closed session and makes a determination which should be available within 24 to 48 hours. Thank you for your time. Hopefully there is a mutually agreeable outcome that can be determined so that this project could proceed.
Sorry,
so thank you.
Sorry, Mr. Chair, I couldn't work out my mute button before, but could I just do a quick follow-up question? It seems
By all means.
like the recommendation or the report from council staff regarding this stormwater issue says that the separate process under local government, and there's no works proposed under adjoining land as part of this application. So is that your understanding, Mr. Baxter? This DA isn't actually seeking consent for works beyond the property boundary of this proposal, and that'll be subject to a separate 68 application.
That's right. So
Right.
that's my understanding, that there's no reason not to approve the DA. I think the section 68 process will determine whether we can in fact tap into the council easement, which is on Andrew's site, or whether for some reason we have to, if they totally block that for whatever reason, then we would have to pursue the council reserve option.
If there's two pieces of legal advice and they conflict, then one's right and one's wrong, but the legality of that will need to be sorted out at that time. So, Mr. Agnew, what's your response to that? That it's a matter for the 68, not now, if there's no works proposed on adjoining land, whether that's owned by council or you?
I would direct the panel to read the advice from Apex Planning Environment Law, whereby they point out that this day, you can see it quite clearly there.
Okay.
No further comments or questions. Thank you both. Thank you, Mr. Agnew and Mr. Baxter. As I said, this will be taken later this afternoon to the closed meeting, and a determination will be published within 24 to 48 hours. Thank you. Okay,
Thank you.
Next item. Next item is 4.4. And I'll just check and see. We have speakers. We have no objectors. This is for the construction of an inclinator at Hudson Parade in Cloville. The applicant, Natalie Nolan, is a planner, and Victor McAuliffe. Both have asked us to address the panel. The recommendation from the staff report is for refusal. So, Natalie, if you're present, would you like to address the panel? And then we can briefly have Mr. McAuliffe as well.
Yes. Hi, thank you for letting us address the panel today. Chair and panel members, my name is Natalie Nolan. I'm a town planner on behalf of the owner and the applicant of this application, Mr. Vic McAuliffe. The dwelling house, which was approved some time ago and is nearing completion, is being occupied by my client Victor and his wife Jane. The need for this application was to provide access down to the foreshore area. They got a jetty down there and to access their boat. As you would have probably seen at the site inspection, if you visited the site, I'm not sure whether that's occurred or not. There's about a 9-metre difference between the rear yard and the foreshore area. So it's a big steep incline. Currently, the only access down there is some stairs. Both Victor and Jane, respectively, are in their later years of life and both suffer from some mobility issues, and hence the need for this inclinator to access and be able to use the asset to which that they own. We have submitted the medical certificate to council as part of our submission, which demonstrates that the access is required for those purposes. And I think Vic might even talk about it. His condition is actually degenerative and is not going to improve. And as the years progress, it's only going to be more difficult for him to access. We did submit a clause 4.6 application to seek a variation to council's development standards in relation to the foreshore area. We believe that the development meets the objectives of that clause. It doesn't affect natural foreshore processes, and it doesn't affect the significance or amenity of the area. The lift or incline lift, if you look at the plans, has been designed to really closely hug to the topography of the land. It doesn't stick out. It's not an overly bulky structure. There's already a bit of landscaping there. And it's merely just to provide that required access to the foreshore area. Clause 7.8 of Council's LEP, which relates to development in the foreshore area, permits a number of structures, and one of those is access stairs. And I think access stairs are not suitable for the people that live at the site. They can't access the area. So this is an alternative and the only option for them to be able to get down to that area. There's been no submissions from adjoining property owners. There is a number of incline lifts or inclinators similar to that proposed in Hudson Parade, and I've noted them in my submission. There was one approved in Elvina Bay across the bay maybe 2 years ago. It was supported by clause 4.6. We're happy to discuss any options. It's just that this is a need to enable safe and effective access to my clients. It's just they can't access the site, that part of their site, or the jetty to which that they own. Thank you, panel members.
Thank you. Any questions from the panel?
You've got one. So the primary reason is for access for elderly residents, is that right?
Yes, it's just for, there's only 2 people that live on the site, and that's, as far as I'm aware, Vic might clarify, Victor and Jane. They both need access to the foreshore. So
I guess, you know, a lot of sites are steep and people do get older in the home. So what would you say to that being a reason to have an inclinator on every site that's steep?
I think they all have to be assessed on their merit and design, so it doesn't impact on the properties. Council's approved numerous ones in the past. His whole house is designed for access for themselves, and that includes an internal lift. I think each needs to be designed, assessed on its own merit.
Thank you.
Thank you. Natalie, you mentioned that you'd contemplate alternate solutions. I mean, have you looked at other options where the inclinator is not totally within the foreshore area? I mean, your comment is, I guess, something that needs clarifying, but I'm aware that there have been minor intrusions into, but not to the total structure being totally within the foreshore area. So my question to you is, have you looked at alternatives which do not involve such an extensive location within the foreshore area?
Yeah, so I mean, it's within the bounds of the site.
It's not. Sorry. I mean, you say you're interested in looking at them. I mean, it's not for this panel to make those design decisions for you. It's for you to look at them and see if there is an alternative, which is not to the same degree intruding into the foreshore area. And that may be something which is more likely to be seen to be similar to what's been approved elsewhere.
I think it is similar to others. So we don't encroach the mean high water mark. So we're within the boundaries of our site. The foreshore line. Yeah, well, the foreshore line extends from that point up, and there is a number, and I've included them in my submission, in my clause 4.6, of others in Hudson Parade that have been approved in the past and that exist, and they're wholly within the foreshore building line. The change of level of the site at the moment, where that retaining wall is, and you can see in the site plan, that's from there down to the base of the boat shed, I suppose you'd call it. That's about a 9 metre difference in height. So they're way better than inclinators that were built 10, 15 years ago. They are close to the ground floor, the ground level at the moment. They follow the ground level. It's not just one straight line. It respects the topography of the site. We just don't believe that it has a negative impact. If there was some impact that council could have raised, that they had one particular issue with it, or is it just that they just don't want an inclinator there at all?
Thank you. Any other comments, panel?
Yes, thanks, Mr. Chair. Just to follow up, thanks for your commentary, Ms. Nolan. Did you or your client explore, I mean, given that it sounds like it's a relatively recent purchase and that the conditions have been around for a while, were there other options explored, particularly some form of lifting that's more, that encroaches less on the foreshore building area? Was that looked at all?
I might defer that to Victor, because I know that he did work with the inclinator or the design person for the incline lift. Yeah, I might defer to Victor for that, to be honest.
So, Victor, if you'd like to comment and make a further submission, please.
Yeah, well, the thing is, it isn't only my wife and I up there, it's also other elderlies as well. Like I've got 8 fixtures there which are older than what I am, right? And we invite them here all the time, and we can't get access there to the waterway, right? Because we're all getting old, and you know yourself as you get old up there, well, your mobility isn't really that good, right? And to me, this is a disability issue. Right, this is what I see up there. Like I got a jetty, well, I got a boat down there which I can't get to. I pay the leasing on the jetty, right on the slipway and everything, and I can't get any access. So that's been my attitude. The only other option I have here, if I don't have any success with the council, I'll have to try to go another avenue. Well, either Land and Environment or the Disability Act, because I don't reckon this is right. Right, your discrimination is against the elderly that have a disability. I don't think it's right. So that's all I can say.
All right,
And,
thank you.
Did you, Mr. Micallef, did you look at a lift a vertical lift, like a strictly vertical lift? Was that an option you explored at all?
Oh, no way in the world. I don't reckon you could do it, and I don't reckon it'll work. But I don't reckon it'll work. It'll, like the earthworks involved up there, you'll be demolishing, I don't know. It wouldn't work. And then how far are you going to get? Like, to me, this is a disability issue up there. Like I build a lot of industrial and units and all that up there, and always up there, mate, you got to have ramps up there for disability, for elderly and everything else. And then you come up here, I buy a house on the water that I can't get access into my jetty or what's that. My poor wife's already had a couple of operations on her hip. I ain't any better. I'm getting old. Another couple of years, I'll be 80. You know, what are you supposed to do? What, you have an area down there that you can't get access to? It just ain't right. It just ain't right. I can't understand how the council, they can even consider that up there, not to, you know, grant the permission to have an inclinator. It's a disability issue. So
Victor,
that's all I
thank
got
you
to say.
Thank
and I
you
would
very
just,
much.
I'd just add, in terms of you saying other examples, if you want to look at the 192, 204 and 252 Hudson Parade, they're older ones, but they definitely go right down to the water's edge.
Yeah, sorry, Natalie, just if you wouldn't mind commenting on Kate's question about just a simple lift.
So yeah, if you just want to, the question is, are you saying just to excavate straight down to get to that level?
No, I mean,
it could be a couple of other options.
Yeah, it's, as I said, we are not here as a means of solving and design solutions, but we're saying, have you looked at something which is perhaps a lift as opposed to something which is an inclinator, which may be a lesser structure and a more justifiable element to put into or relate to the foreshore area?
Yeah, I suppose from a point of view of the excavated lift and lift that would go from that level is a significant amount of excavation and would alter the landform and vegetation that's surrounding. I think a lightweight structure that sits atop the ground is a better outcome.
Yeah, but if you have a look at the design of the lift, it only goes down halfway on an angle, and then it is like a lift. It just goes all the way down straight. Right, it already goes all the way down straight.
Without altering the landform to such, you know.
Yeah, right, but you can't go down. I can tell you, I'm a builder, right? I'm a builder, and I'm telling you, you can't have a lift there.
Thank you both for your responses. Are there any other comments the committee would wish to make or questions? No, as you've probably heard, we will go into a closed session now, and the determination of the panel will be made and published within 24 to 48 hours. So thank you for your time and your submissions to clarify some of the issues that you relate to us. Thank you.
Thank you.
Thank you.
Thank you.
Okay. Panel, that's all of the items we have for the public meeting. So I would, unless there's